Judge Schwab said, your client is stating he wants to settle, and he kept saying, no, he does not have the right to settle. I am his lawyer. I make the decision.
In that contingent fee agreement, what is the percentage? 40%.
Mr. Considine reacted in a manner in which I don't think I've ever seen a lawyer react, to be frank.
I never experienced anything like that in 14 years. I felt he was melting down.
What year were you admitted to the Pennsylvania bar?
1992.
And your current position is United States Magistrate Judge for the Middle District of Pennsylvania?
That's correct.
When did you begin in that position?
December 1st, 2013.
Okay.
Or it could be 2012. I don't know. 2012, I think. I'm on the bench 14 years in December.
You conducted a settlement conference in the Hale versus Lice case in the Middle District. Is that correct?
Yeah. Yes.
And that occurred on December 14th, 2023. All right. Did there come a time during the settlement conference where there was a specific offer that the Hales wanted to accept?
Yes.
And can you please tell the committee what occurred from that point forward?
What I remember was that Mr. Considine did not agree that the Hales should accept that offer. And I mean, here's what I remember. I remember it being like an issue between the attorney and the client, and it started to deteriorate. The relationship started to deteriorate. I recall there being probably, I think he tried to call them on the side and talk to them. But what I remember most is that Mr. Considine was on the phone and he could hear them through the Zoom and they could hear him. And he was telling them that they didn't have the authority to accept the offer, that only he had the authority to accept the offer. And that was wrong. What I did then was I called my law clerk in because I felt like I needed somebody to be with me, because I usually just handle these things on my own. So that this was now a very precarious situation. I think I said, this is enough. It had gotten to the point where it was way out of control. And as the settlement officer, I made the decision to end his participation politely, but said, I'm gonna hang up now. I never experienced anything like that in 14 years. As I recall, I terminated the call because he was saying only I can settle, which is not accurate, as we all know as lawyers, and he was getting increasingly more agitated. There was like a complete breakdown in decorum and professionalism, and just his voice was I felt he was melting down, so I just ended it.
Did he reasonably and adequately consult with you about the means to achieve your objectives in your case?
No.
Can you give examples of that?
How he did it. He basically told us that he did not miss a discovery deadline. But for 3 years, he was trying to claw back that time frame. And he never informed us of that. If I knew he missed the discovery, I would have fired him right then.
Well, you were driving your car and you struck a parked car, if I understand it, by accident?
No. Exactly wrong.
Tell me, that's what I'm asking. I wasn't there.
An employee of Hershey came out from a side street and hit us behind the second passenger door at 3 o'clock.
That's in the afternoon or morning?
No, 3 o'clock on the clock of the car. So at 3
Okay.
o'clock, he hit our car.
Yeah, I should have known, you are a military man. Now, why did you get into an argument with the cops? That's what I want to know. Did you lose your temper?
Because they didn't do their job.
And you turned a civil matter into a criminal matter where you were charged with aggravated assault and other things on the officers, am I right?
3 weeks later.
But you agree you
3
lost your
weeks.
temper? Go ahead.
3 weeks later, after they found out that I lawyered up, they brought erroneous charges, a whole list of them.
But you would agree that you lost your temper with the police during that stop?
Well, if you were in handcuffs and tased 6 times, you'd get upset too, wouldn't you? And then thrown into a paddy wagon head
But
first.
Good afternoon, Ms. Valentine. Michael Gotch from the Office of Disciplinary Counsel. Now, is that something that you wanted to do to help with that case?
No, I had, from the moment that he was looking for a lawyer to file a lawsuit, a civil suit, I did not want to have any part of it. During the course of this trial, Mr. Considine, on many, many occasions, was not able to do simple tasks, not handling Microsoft programs. He couldn't open USB sticks. I had to download documents and send it to him. He would lose them. He didn't know how to open videos. He called and asked for instructions on how to open videos or video viewers. I had to download documents, send to the judge. There was multiple things that he did not do that fell on my lap that I had to complete.
Okay. And how much time on an ongoing basis would you say that you had to devote to this?
'Cause I was doing, looking and providing documents, et cetera, probably sometimes a couple hours a day.
And for how long did that last?
Well, the civil lawsuit lasted from 2019 till 2024.
Did you authorize Mr. Considine to name you as a plaintiff in the case and assert any claims on your behalf?
No, I did not.
Did you ever enter into any fee agreement with Mr. Considine?
No, I did not.
Did you ever agree that it was okay for him to assert a claim on your behalf?
No, I did not. The early conversation, most conversations were between Thomas Hale and Mr. Considine. And at the time, there were some calls on speaker that he had said that there could be a possible claim for consortium, but it would be little or to no value. And I, at that time, said that I am not interested in being part of this claim. I was not there during the incident that happened to Thomas Hale, and that this is a lawsuit that Thomas wanted to pursue.
You attended the October 1st, 2024 hearing before Judge Connor. Is that true?
Yes,
Now, do you remember Mr. Considine during that hearing stating the following? So we discussed the loss of consortium claim, and she agreed that she had a claim. And in fact, we even discussed what the value of the claim was, what the value of that compared to the excessive force claim. Do you remember him saying that?
I believe he said that during that court case.
Right, this was the hearing before Judge Connor.
Yes,
And what I just read you, was any of that true?
no, it was not.
Now, What was the nature of this tirade? Was it raised voice, or how did that work?
Yes, he was yelling. He was upset. He was, I almost want to classify it like a tirade or a temper tantrum. It's basically the words I would use.
Okay. Now,
And he walked out.
good afternoon, Mr. Hale. Michael Gotch from the Office of Disciplinary Counsel. Could you begin by just giving a brief sketch of your personal and educational background?
Sure. Petroleum and natural gas engineer from Penn State University, followed by 35 years with Shell Oil Company in the commercial business-to-business realm. In my last 10 years, I was one of 200 employees that was accredited deal maker in Shell. Just to let you know, there's 90,000 employees in Shell, and there's about 15,000 commercial B2B employees. So I was one of 200 that was accredited to do major deals.
When did you become involved in assisting your brother Thomas with his civil case?
After building my retirement home in Wilmington, North Carolina in October of 2021. Yeah, I showed up, rode from Lancaster to Harrisburg with Tom and Penny. We got there early. I introduced myself to Mr. Coltash. I had my business suit on. He thought I was Tommy's attorney. I had to correct him that no, I was not his attorney. Mr. Considine showed up late. He looked unkept and he was unprepared for the meeting. He continually asked to, throughout the day, just go down to the law library and find a case that would support Thomas's position, when I felt that he should have done that prior to the mediation. So Thomas wanted to start out like at 19 million. Michael wanted to start out at 6. Basically, Michael made Thomas compromise. We started out at 9.7 million to be exact at 10 o'clock. Kroll started out at 10,000, opposing counsel. I had warned Thomas beforehand based on research for this court and for this jurisdiction that typically these civil awards end up around $200,000. So we discussed about a strategy which I learned about in my commercial classes at Shell about broadening the pie. So Tommy's VA benefits are something like $7,000 a year in round numbers. Plus he has some
7,000 a
SSDI.
month. 7,000 a month, not year.
Correct, 7,000 a month.
Right. You said
So,
year.
and his SSDI is about $2,500 a month. So if Tommy went to jail based on the criminal charges at hand, which were very numerous, he would lose his Navy benefits, VA benefits. So if he lived for 30 years, that's about $2.5 million in round numbers. So by bundling the civil charges with the criminal charges, at the end of the day, we felt that that created value for Tommy. Obviously not much value for Mr. Considine. So the offer at the end of the day was $150,000 plus contingency of dropping all criminal charges. Mr. Kroll said, that's above my pay grade. I'll get back to you. I need at least till Monday, 2 business days, 5 calendar days, plus or minus, to escalate this to the DA, Shardo, and I'll get back to you. The following day, Michael Considine fired off an email to Kroll stating, we'd like to know by the end of today, Friday, close the business, whether you're going to accept the offer or not. Thereby kind of killing the deal and pissing off Kroll. Kroll came back on Monday saying it's $150,000 or nothing, take it or leave it. Tommy sat on that for a day and said, I'm gonna leave it on the table. I'll fight another day. Toward the end of the day, once Mr. Considine realized what we had done with the bundling and that his 40% contingency would be a lot less than he envisaged.
Section
Sustained.
speculation.
Just answer the question.
Yes, they were fighting back and forth.
Okay.
At the end of the day, Michael Considine stood at the door with his bags packed and refused to meet with Jonathan Coltash in the mediator room, which was in between the two rooms. He was going back and forth between Kroll's room and our room. He refused to meet with Jonathan Coltash, summarize the deal on the table, and schedule action items, next steps, et cetera, to make the deal binding.
Right, so was he forceful about opposing it, or what did you observe?
Let the witness tell what he was like.
Go ahead.
Well, if you're standing at the door with your bags packed, ready to leave, and not willing to speak to Coltash and Kroll about next steps, what does that tell you? He was on his bike, ready to leave without finalizing the deal.
Good morning, Mr. Coltash. Michael Gotch from the Office of Disciplinary Counsel. How are you today?
I'm well, sir. And yourself?
Fine, thank you. You were the mediator in the Hale versus Lice case in the Middle District of Pennsylvania. Is that right?
It's correct, sir.
And that mediation occurred on September 8th, 2022?
About that time. Yeah, that's correct, sir. Sorry, I thought you said 02 for a second. I was like, I wasn't barred in 02, but 22, yes. The Hales at that point signaled that they were willing to take, I believe it was $150,000. And then Mr. Considine reacted in a manner in which I don't think I've ever seen a lawyer react, to be frank. I think I went after him to the elevator bank and I said, wait a second, we're trying to resolve this case. He wouldn't speak to me. He was very clear that he knew the rule that they couldn't continue without him. I went back into the mediation room and then informed his client, who I'm now left with, that I had to terminate the mediation and report back to the court that the mediation was unsuccessful. There's a form that we check. Successful, unsuccessful, needs more time. Under the rule, I checked unsuccessful. The Hales indicated to me at that point that they wanted to accept the deal. I told them that I terminated the mediation. There was nothing more I could do. That they needed to contact their lawyer. They asked me questions that were uncomfortable, like, can we fire him? And I didn't want to get between him and his client.
And he told the clients, don't agree, it's too low, we can get more money, or words to that effect.
It was, you can't accept this deal without me. You're leaving money on the table. I won't be part of it. And he walked out.
Now, you said that he acted worse than you've seen anyone during mediation. You called it a temper tantrum, or was it just? Go ahead, tell me. Was it?
Yeah, I've described it that way consistently. I walked out of the courthouse that day. I was appalled. I called Mr. Barrett and said, I'd never seen anything like it. And I described it then as a temper tantrum. And I've described it that way consistently when the court's asked since.
From the time he said, we don't want this deal, and made the comments, to leaving money on the table, whatever, until he walked down the hallway with you following him, trying to convince him to come back. We talking just a minute or two? Are we talking 10, 20 minutes?
3 or 4 minutes at max. He was wildly packing his bags up. He was extraordinarily agitated. He wasn't flailing his arms like one of those things out front of a car dealership, but wild gestures. I mean, he stormed off, loudly stormed off, throwing the doors open, heading to the elevator. It was behind a door. There was a marshal there. There had to be a marshal there because they had to badge us in and out. Even the marshal was like, what the heck just happened here? Like it was a storm out. That's doors flung open. He stormed out.
All right, so could you please tell the hearing committee what happened during the settlement conference before the magistrate judge?
Judge Schwab,
Correct.
Penny, myself, and Michael were on video. Judge Schwab allowed my brother to be on the telephone, just to listen.
Now, at the settlement conference, did Mr. Kroll, representing the defendants, offer you $200,000 to settle the case without any reference to the criminal charges?
Yes.
And what was your response?
Deal.
And why is it that you wanted to accept the $200,000 offer that day?
I just wanted to get this over with and out of our lives.
Mr. Hale, did you tell Mr. Considine that you wanted to accept that $200,000 offer?
Absolutely.
Please state what you observed.
Wally was ranting and raving about the 200,000 that he can get $500,000.
And Mr. Considine kept in saying that, no, you're not accepting that, or I have the right to tell you no, he's not accepting that offer. And Judge Schwab said, yes, Mr. Hale has the right to accept that offer. And he says, no, he does not. And Judge Schwab said, your client is stating otherwise, he wants to settle. And he kept saying, no, he does not have the right to settle. I am his lawyer. I make the decision. He's not settling. And Thomas kept saying, I want to settle. I want this over with.
Okay, you said he blew his cool. Can you explain what you saw?
Yeah, I remember his words like it was yesterday. He told Judge Schwab that both Penny and Tommy were suicidal. They don't know what they're doing, blah, blah, blah. I'm their attorney. I know better. They need to listen to me. I know I can negotiate a better deal. I'm not accepting these terms.
When Michael ranted about us wanting to settle for 200, he basically closed his laptop. You can see him do it on video. He just closed it. Disconnected. He was calling my brother to have him call me to tell me not to settle. He can get more money. So while he was supposed to be talking to the judge, he's calling my brother, telling him to convince me not to settle.
Kroll felt sorry for Thomas, what was going on, so he added another $50,000 at the last minute. Toward the end,
I had 500.
Mr. Considine was not happy with that, obviously. He ghosted the conference and decided to call me on my cell phone. I took the call. He tried to convince me to convince Tommy not to take the deal. I reiterated to Michael several times, your client is suicidal. They're tired of the stress. This happened August 31st, 2019. It is now almost 5 years later. They want this over and done with. They want to get on with their lives. You have to listen to your client. He obviously blew his cool and ghosted the conference. So
Objection, we ghosted the conference.
What do you mean? By that? What do you mean by ghosted the conference?
he went off the video. He went off the video for like 30 minutes. Judge Schwab tried calling him several times.
Judge Schwab kept saying, where's your lawyer? Where's your lawyer? And we said, we have no idea where he is. We can't even reach him. And she said, well, I'm going to try and reach him. And she kept calling him. He wouldn't answer his phone. And finally, after some time, like she said, this is so unacceptable. Finally got him on the phone.
Did he say anything to his client, Mr. Hale, at that point, or was it just a conversation between you and Mr. Considine?
No, the Hales were always on. They were listening to this. See, here's the phone, right? Here's the phone, and the Hales were on Zoom, just like I'm on with you. So they could hear what he was saying.
But despite his agitation, the bottom line was he was trying to convince his client not to accept the settlement offer because it was too low, or is not your recollection, Your Honor?
That is not what I remember him saying. I remember him saying, only I can accept a settlement offer. Mr. Considine either called me back. I wouldn't have called him. I think he called me back and he was really, really upset and he started to cry. And saying he was sorry.
Then after the phone call was concluded, that you ended it, per your recollection, how long before you received that phone call you said where he apologized and was crying and things of that nature? Was it right away? Was it an hour later?
No, it was pretty soon after, within a couple minutes.
And then he said, we're not accepting the offer. And Judge Schwab stated that, yes, I am going back to Mr. Kroll to say that this settlement is settled. The offer is $200,000 and it is final. And he said, you can't do that to that effect, that he can't accept unless I accept. There's more money on the table. He was trying to yell over Judge Schwab during the settlement. And finally, Judge Schwab said, this is final. You'll be hearing more information after, and she closed.
Other than the very top where I think it was forwarded, an email from Mr. Considine to you and Mrs. Hale, forwarding the release and stating, I have read the release. There is nothing in it I find objectionable. Please date and sign it and return to me. Do you see that?
I do.
If I may, for background, before I ask another question, refer the committee to paragraph 64 of the stipulations, the fact, which states that on or about January 18th, 2024, Defense Counsel mailed the settlement release to respondent, and respondent forwarded it to the Hales stating, I just received the release right now, but have not read it. Please date and sign it and return it to me. If you have any questions, please direct them to me by email.
Correct.
There's an email at the bottom half from Penny Lee Valentine to Mr. Considine stating you have not read this release and you are not advising us.
Objection to that, unless she's going to testify.
That's a stand. Speaks for itself.
I'm just going to ask you to look and take a note of what time did Penny send the email to Mr. Considine on January 23rd. Pardon me?
9:30 a.m. 9:28.
And if you look up then to his reply, what time was that sent?
His reply was 9:44.
Right. So would you,
Don't know how he did that. Sorry.
and so in the email, you state to him, as of today, January 7th, 2024, Michael Considine, you are hereby terminated, correct?
Correct. Correct.
But the January 7th is just a mistake. You meant February 7th. Is that right?
Right. Right.
Okay. Mr. Hale, do you remember seeing this motion to confirm and enforce settlement?
Yes.
And up at the top, the PACER indications show, I think, that it was filed on February 26, 2024,
Yep.
well after you terminated him, right?
Correct.
And roughly in the middle of the document, the proposed order that Mr. Considine submitted states, defendants are ordered to send a check in the amount of $200,000 made out to Thomas Hale, Penny Hale, and J. Michael Considine Jr. to J. Michael Considine Jr. PC at his address. Leave is granted to J. Michael Considine Jr. to sign his name and those of plaintiffs on the check and deposit it into his escrow account. Do you see that?
I do see that.
Did you raise anything with him at the time you first saw it?
Yeah, I said he's not getting any money.
Did he ever ask for your consent to be able to sign your name and Penny's name to the check?
Never. Never signed a document for him to sign anything in my behalf.
Okay, we're ready back on the record and back in the hearing. The panel has deliberated and found there's a prima facie case of a violation or more. We found at least one violation, and therefore we want the respondent to proceed with his case in chief. Ready to proceed.
I'm ready to proceed, so I can, just to make sure, I can present not only on the merits, but also on the nature of sanctions.
Exactly.
Good.
All right, we're ready to proceed.
Case to be sworn in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
All right, now, good morning, Mr. Constantine. You have had one case of prior discipline, am I correct? No formal admonition?
The only thing I had was, I had, I know you represented me and it was, maybe you can recall the facts of that case, but
I'm going to hand you.
can I just explain briefly what happened in that case?
Yes, go ahead.
I was representing a person in a civil rights case, and we discussed charges being dropped with a witness, and I didn't know that that was a violation, just like I didn't know this was a violation in this case, because this happened before this. I realized that it is a violation. I admitted that it happened and got an informal admonition. That's my only discipline.
And in that contingent fee agreement, what is the percentage?
40%.
And who signed that contingent fee agreement?
Thomas Hale.
Is his wife listed there?
No, she's not.
Did you represent her in the litigation?
Yes, I did.
And what was her claim for relief?
Her claim was a loss of consortium claim. She was doing a lot of things for him because he was in a bad way. He needed a lot of care.
And why did you have her sign the contingent fee agreement, or now a separate contingent fee agreement as a practice in more modern times?
These were some of the most demanding clients I've ever had in 44 years, and I made a mistake. I should have given her that. But I didn't do it. It was wrong.
Indicated that you had some kind of temper tantrum, as so did Mr. Hale's people, and that you left abruptly, crashing arms and acting very badly. What happened?
It didn't happen. I never flashed my arms. When we reached this deal, there was nothing to stay for, and I left.
Did you advise your client to accept the deal or not?
I advised them it was not a good deal, but they told me that's the deal they wanted, so I had to communicate it to the other side. So I did, and then Mr. Roll, communicated this back, confirming that. But I didn't have any problem with Mr. Coltash. I think he just doesn't have good memory, but I never said that I control the deal. I knew that if the client agrees to an amount that's been offered, then you may get some time to try to talk the client out of it, but otherwise it's a deal. Okay, I knew that, so I never said what Coltash
Did Mr.
said.
Kotesh chase you to the elevator and beg you to come back?
No, it never happened.
The judge said you acted badly during that call, and you hadn't seen anyone act like that before. Is that correct?
It's not correct.
Did you raise your voice?
I didn't raise my voice. I was upset at the clients, and I never said that I had the right to deny settlement. I never said anything. I never said that. And she couldn't even remember that the case settled that day. I mean, it settled that day.
The judge indicated that you called back a few minutes later or whatever that day and were crying on the phone and apologizing. Did that occur?
No, I don't recall ever crying or apologizing to the judge.
I want you to try to explain to us why 5 people are saying you had moments of temper tantrums or became unhinged for periods of time, but you're telling us it didn't happen.
Well, I can tell as to the Hales, the practice of law has changed. And now there is a deliberate strategy by some clients to lie about an attorney so that they can steal their money. And that's really what happened here, is that they lied about me in a way to try to keep me from getting my contingency fee.
Is it possible that you perhaps could have gotten a little upset and emotional during some of these matters that would have raised some concerns with Mr. Kotash, Attorney Kotash, and the judge? which caused them to testify. Is it possible that you got upset with your client and showed it a little bit?
Yes. Now, will you accept my representation that in your answer to the DB7 letter, you accused the Hales of lying and being liars 16 times? Or do you want to go through and have me point out the paragraphs? Because I counted them.
Not just 16 times, there's more than that.
More than that. Okay, that's fine. So we won't have to go through each one.
In number 21, I said this is not true.
Right.
And in number 23, I explained this is all true except. Number 24, I said this is not true. Number 26, I said this is a lie.
Can you tell me how many times Mr. Stratton accuses the Hales of lying?
I don't know, but
Would you accept my representation that he does not ever call them liars?
I don't know if he did or not.
Did you? Well, wait, you read it and verified it, right? All right, so ultimately, Judge Connor found that your testimony at the October 1st, 2024 hearing was not credible.
Objection.
That's
Move for mistrial.
sustained. No mistrial, that's no mistrial, and it's sustained.
You said, quote, "I never said anything like what the judge had said," you said. Do you remember testifying that?
Yes, I did.
Now, is it possible that their memories are correct and yours isn't?
Anything's possible.